His Royal Majesty King Letsitsa Moloi of the Bagolokwe Kingdom as the upper house calls for the African National Congress as the lower house to come home by removing the top 7 executive of the African National Congress, which is Matamela Cyril Ramaphosa as the president and the deputy president Paul Mashatile and the chairperson Gwede Mantashe, Secretary General Fikile Mbalula, first deputy secretary general Nomvula Mokwanyane, second deputy secretary general Maropene Ramokgopa, and then treasury general Gwen Ramokgopa. They are requested to be in court in terms of a subpoena that is being filed in the Free State High Court for them to attend court on the 24th of July 2024 at 10:00 or soon thereafter, as the parties may be heard in terms of the prayers that are before court, where all media houses internationally and locally are called to show the world that which has been hidden from the people, in that the African National Congress did not form itself. It was formed by the kings and queens to go and ensure the return of the land and human dignity of the kings and queens. And the respondents in particular, the 2nd to the 8th respondent, have failed in performing their mandate of office. And the grounds upon which they are being removed or required to renounce their right as office bearers is such that they have grossly violated the Constitution or the law and seriously misconducted themselves, and they are unable to perform the functions of office, as it has been proven since this particular matter has been on record on 8 May 2025, in which the respondents were required to file their answering papers on 12 May 2025 for the matter to be ripe for hearing on the 13th day of May 2025. And all that has been done to this day is that the respondent have shown and proved that they are indeed unable to perform the functions of office, even after being called in terms of a court order mandating the parties to come to an agreement relative to the filing of answering papers. They ignored the court order, and the applicants went in terms of section 1654 of the Constitution to assist and protect the dignity, accessibility, impartiality, effectiveness, and all the core values of the court, to show cause that we can come to an agreement relative to these applicable terms, in which the respondents must file their answering affidavit on a set particular date, and then we file our answering papers on this particular date. That particular date was in fact the 8th of July 2025, and then we shall file our answering papers on the 11th of July, in which on the 11th of July we went in an ex parte application that was dismissed with cost in front of me, but the court order does not say dismissed with cost. And I was caused to lie to His Royal Majesty relative to the terms of the court order, because I was told in court record that the matter is dismissed with cost. And then I have subsequently asked the court to correct itself in terms of Rule 42(1)(b) of the Uniform Rules of Court, and rescind or vary this particular reality, such that the prayers in the notice of motion are made an order of court for all people to comply with section 1951G of the Constitution, first in Part A, for the matter to be televised. We cannot be in a position where a judge, in terms of Article 6 of the Code of Judicial Conduct, is obligated to at all times, also in relation to extrajudicial conduct, comply with the law of the land, and they are paid a salary to do so, however, but they don't comply with the law of the land. The first prayer in the notice of motion is a direct copy and paste of section 1951G of the Constitution. And I do not go to court to argue with a judge relative to the applicable terms that the judge has sworn to uphold and protect the Constitution. and be faithful to the Republic, and administer justice to all persons alike without fear, favor, or prejudice in accordance with the Constitution. I come to court to resolve a dispute by the application of law, and the applicable law that has been applied here is the obligations imposed in terms of Section 1951G of the Constitution for transparency to be fostered by providing the public with timely, accessible, and accurate information. I am not asking the court to do anything out of context of the Constitution. That is why I ask the acting judge president, the Honorable Madam Justice Mbele, to grant a full bench as per the record of court. We have came to you in terms of Rule 4918 of the Uniform Rules for the court for this matter to be heard by a division, 3 judges. And that particular reality is the reality that we expect on the 24th of July 2024, when the courts regain their independence and they subject themselves only to the Constitution, not the corruption, criminal activity, or misconduct that is being brought before the court for it to resolve by the application of law. So all media houses and the acting judge president and the judge president Musi of the Free State High Court, please provide us with a full bench to hear this matter. We only are asking for judges that have sworn to be faithful to the Republic and have sworn to uphold and protect the Constitution and the human rights enshrined in it, and have sworn to apply the law to all people alike without fear, favor, or prejudice, and in accordance with the Constitution. The rules have been followed to the letter. The matter has been set down for hearing in accordance with the practice directives for the opposed motion in such a matter that the matter must be set down on a Friday for it to be heard on the next Thursday. So that has been done, and the parties will be served with that particular reality as they receive this particular video, because I do not want any ambiguity. The ambiguity that has been caused by His Lordship, the Honorable Lobsa, who has said that he will not grant the Rule 42(1)B notice, and we must take a long route and file for an application for leave to appeal. The rules are the rules. Judges must comply with judges. Lieutenant General Mkhwanazi, you are required to read and apply the applicable terms at Section 104, subsection 17 of the Defense Act, in that any person who undermines or stifles or seek to undermine or stifle any grievance procedure for any redress for a grievance procedure is liable on conviction to a fine or imprisonment for a period not exceeding 5 years. This is the law of the land that Judge Lobsa does not want to comply with. And they want to put a blame on us as the applicants who are abiding by the law. So we request all law-abiding citizens to be present in the Free State High Court with their phones to record and tell their friends and family or the public, and provide them with timely, accessible information. You can be in a position where you comply with Section 1951G of the Constitution and record the proceedings, because everything that needs to be heard in that needs to be averred or advanced in those proceedings must be heard by all people in the world, because this matter is a matter of national security. And the Chief of the South African National Defence Force, you must structure and manage the Defence Force as a disciplined military force. That is your function in terms of Section 201 of the Constitution and the law at Section 14L of the Defence Act. Section 14, it deals with your functions as the Chief of the Defence Force. And we expect the same protection that you want to give to Matamela Cyril Ramaphosa to be the same protection that is given to His Royal Majesty King Letsitsa Moloi. For God has indeed blessed Africa. Papa Otenga.